we could have the knowledge sharing with each other to get this session, to have this session is a great session for today's webinar. So as you all know that valuation under the insolvency and bankruptcy code is a crucial one. It's the role of the RP, the role of the valuer and the other stakeholder in entire process is very, very crucial. And the valuation is the, you can say, the backbone of the entire resolution process, because the valuation plays a crucial role in the CRP process, in the liquidation process, and whatever more it is, even in the voluntary winding up or liquidation process. So this is a very crucial things which everyone, every stakeholder has to ensure that the process are conducted in a very, manner which is prescribed here. So let us now explore what are the features and benefits of valuations under the insolvency and bankruptcy code. Just a moment. Yeah. So valuation exercise is very critical activities, as all are knows, and it is assumed a great importance towards the objective of the entire insolvency and bankruptcy code. That is the time-bound resolution, value maximization, and the balancing of the rights of the all the stakeholders involved in this entire process. Under the IBC, the asset valuation is the core feature which dealt with the CRP process and the liquidation process. The process is conducted by the registered valuer. The process of valuation is conducted by the registered valuer, or they are known as the valuation professional, who helps in determine the current value of the assets which are to be liquidated or which are to be resolved. So the valuation process, even the registered valuer as well as the valuation professional, you can say, and the insolvency professionals having the major role to play. They have to, in combination as a teamwork, to uh, try to get the current value of the assets so that the value can be maximized. And if the CD is into the liquidation, the realizable value can be maximized by this valuation process. So keeping in mind the object of the IBC, this valuation exercise is very important here in the entire IBC process. The requirement of the valuation under the IBC is an important concern for the RVs in all three assets, because there are three class of assets which are prescribed under the IBC, for which the resolution professional has to get all the asset class to be valued separately by the valuation to be conducted by the registered valuers. And the class, as you all know, that is the first class, the PNM, plant and machinery of the corporate debtor. Second class is the land and building. And third class is the securities and financial assets. So all these class of assets to be valued as per the provisions of the IBC under the strict norms of the IBC and regulations framed thereunder. The key objective of the valuation is to have a transparent and a credible determination of the value of the assets to facilitate, please note, to facilitate comparison and informed decision making by the committee of creditors. So the exercise of the valuation is a very important exercise, very crucial exercise, which enables the committee of creditors to take the informed decisions by the valuation. So it shows how important it is. Now coming to the next part of my presentation, that is the purpose and importance of the valuation under the Insolvency and Bankruptcy Code. The valuation under IBC aims to provide a fair assessment of the value of the assets and liabilities and equity of the distressed companies. So by way of valuation, we have to get the fair assessment of the value of the assets, liabilities, and equity of the company under insolvency. It is crucial to in determining the worth of the company and ensuring that it is sold at a judicious price, thereby safeguarding the interest of all stakeholders. So the aim of valuation under the IBC is laid down to determine the assessment of the fair value of the assets of the company. The importance of the accurate valuation have been, I have jotted down this some importance of the valuation under the IBC. That is, valuation report guides the actions of the insolvency professional, COC, and NCLT. So this is the valuation report which is in center, which guides the IPs, the COC, and NCLT in achieving the objective of the IBC through the resolution or liquidation of the company. Fair value and liquidation value are frequently used by IBBI for statistical purposes to gauge the performance of the IBC. So because the values, the fair value and liquidation value, based on this, the resolution happens, or the liquidation value, or under the liquidation, the value of the asset realized. So IBBI uses the valuations, the fair and liquidation value for statistical purposes to gauge how the IBC is performing, how the company is being liquidated, how much the value has been realized in comparison to the fair value and liquidation value. So the importance of the accurate valuation lies here. A registered valuer typically competes with the market and endeavors to estimate a value that is more authentic than the price of an asset. So here the valuer has to determine the authentic price of the assets. Although he has to consider the information provided by the RP, he has the information gathered in under his assignment, but the objective, the essence, the valuer has to get the authentic value rather than a mere value of the assets. The valuation report is a common cause of dispute for financial or operational creditor and may cause a delay in the corporate insolvency process or liquidation process. Because, there are many cases, there are many processes where the valuation report had been challenged, especially the suspended board never, never happy that the valuation is done correctly. Even some of the COC members also raised the doubt. So the valuation report always has been the common cause of the dispute between various stakeholders, and the court has to decide in some cases. I will discuss some of the cases in the latter part of my uh, presentation. The difference in the facts between two valuation reports can be trouble for IRP, RP. You know that under this IBC scheme, there are two valuers required to value each class of assets. So the difference in facts between two valuation reports can be trouble for RP, because if the estimate of the two different valuation reports are significantly differ, then IP has to appoint the third valuer and get the valuation as per the prescribed procedures and norms here. A few of the possible effects of undervalue or overvaluation are as under. First, let us assume if there are undervaluation of the assets, what would be the effect? The effect would be one abnormal gain by the resolution applicant or promoters of the company. If the value is undervalued, the resolution applicant would get the assets of a higher value for which he might have paid the price very less. So this is the effect of the undervaluation. Loss of realizable value for financial creditors and operational creditors. Yes, if the price paid by the RA, resolution applicant, the recovery will be less and the OC and FC would be getting the lesser value than it might be get if the valuation is accurate. Here we are assuming that the valuation is undervalued. Third possible effect would be possible loss of reputation for registered valuers. You know, the valuation or the professional who did who does the exercise of any of his profession, the reputation is a very important thing which one has to keep in mind. All his future assignments, all his future work will be suffered if one has lost his reputation. So here the registered valuer would definitely lose his reputation if he is not conducting the accurate valuation. And now let us know what would be the effect on overvaluation. Under the overvaluation, presuming that the valuer has done the overvaluation of the assets, then the main thing would be the rejection of the resolution plan, which could have been approved. See, as a IP, as insolvency professional, if the valuation is done overvalued by the registered valuer, then the financial creditors in almost all the cases do not prefer to get the company dissolved rather than to liquidate if the value faced are lesser than the liquidation value. So if the assets are overvalued by the valuer, then there would be a possibility that the plan would be rejected. And this is not the objective of the IBC. The objective of the IBC is to resolve the CD, obviously with the fair value of the assets. So here the valuer has to keep in mind that he must not value the assets which is overvalued. Another possible effect of overvaluation would be delay in liquidation process due to requirement of repeat the process. See, if the asset is overvalued, then there would be some objections, some concerns by the COC, by the other stakeholders, and the process would be delayed. So this is the possible effect of overvaluation. Now coming to the statutory provisions under the IBC vis-a-vis the registered valuers. So let us discuss the provisions. Just a second. Yes. So firstly, section 59, subsection 3, clause B, subclause 2 of the IBC, which states that where a proposal for voluntary winding up has been made by a company, the declaration of solvency given by the directors shall be accompanied with the valuation report issued by the registered valuer. So here under the voluntary winding up process, section 59 subsection 3b2 of the IBC prescribes A declaration of solvency which is given by the director shall be accompanied by the valuation reports. The requirements of the valuation arises here under section 59 subsection 3 in case of voluntary binding. Now, another section which enables the appointment of the valuers, or you can say the issue of the valuation reports, that is in case of avoidance transactions as undervalued. Section 46 subsection 2 of the IBC provides that in an application for avoiding a transaction as undervalued, the NCLT may require an independent expert to assess evidence relating to the value of the transactions. Here, the power has been vested with the NCLT. We can appoint an expert, an independent value to value the assets to decide on the avoidance transactions whether the particular assets is undervalued or not. Another requirement under the IBC is regulation 27 of the CRP regulation. What section 27, what regulation 27 prescribes? It mandates the appointment of 2 registered valuers. This is the backbone of the valuation under the IBC, where the enabling provisions for the appointment of the valuer comes in. So it lays down that the valuers, that the resolution professional shall within 7 days of his appointment, but not more than 47 days of the commencement of the CRP process, appoint the registered valuer. 2 registered valuers under each class has to be appointed by the RP here as prescribed under regulation 27. Now another regulation 35 of the CRP regulation states, which prescribe that the 2 registered valuers to be appointed as per regulation 27. Then if the 2 estimates, here one has to understand it very clearly, that if the 2 estimates of the value, because every valuer has to give the estimate of the fair and liquidation value. If the 2 estimates of a value in an asset class are significantly different, the first condition would be it's a significantly different. The estimate of the value is significantly different first, or on receipt of a proposal to appoint a 3rd valuer from the committee of creditors. The another scenario may be the COC itself proposed to appoint a 3rd valuer. Then the resolution professional may appoint a 3rd registered valuer for an asset class. So there are 2 scenarios. First, there are significantly difference in the estimate of the value. The resolution professional has to appoint the registered valuer. And if there is a proposal from the committee of creditors that we have to appoint the 3rd valuer, then the 3rd valuer may be appointed by the RP for the asset class where the significant difference is there. So what is the significant difference which we can understand here? So significantly different difference which was not earlier defined in the regulation, but after amendment the significant difference has been defined. So it is a difference of 25% in liquidation value. It is not saying about the difference in fair value. It is saying about the liquidation value, the difference in the liquidation value under an asset class, and shall be calculated as the formula has been devised L1 minus L2 oblique L1, where the L1 would be the higher value of the higher valuation of the liquidation value. L2 would be the lower valuation of the liquidation value, and divided by the L1 higher value. So the difference would be arrived here, and if it is more than 25%, it is significant, it's a 25%, not more than, then this will be deemed that there is significant difference, and RP has to appoint the third value in that particular class. And after that, what would happen? The average of the two closest estimate of a value shall be considered the fair value or the liquidation value. So here, sorry. So here the average of the closest estimate. Suppose, let us take an example. If the say asset class plant and machinery, the RP originally conducted get the valuation, estimate valuation. Let us talk about the liquidation value only. 100 crores plant and machinery valuation estimate given by one registered valuer, and another registered valuer given the estimate of the liquidation value, that is 150 crore. So we would have to arrive the difference whether it is significant or not, since the first valuation is 100 crore and another is 150 crore. So there is significantly difference because it is more than 25%. Then RP has to appoint third valuer under the class of plant and machinery, then get the valuation. Say the third valuer appointed by the RP gives the valuation, estimated liquidation value, say 130 crore. Then closest of the two. So now in that case, you would be having three value, 100, 130 and 150. The closest of the two would be 100 and 130. The average of the two closest estimate of a value shall be considered at the fair value or the liquidation value as the case may be. And so the average of these two closest value would be taken as the liquidation value of that particular class of assets. Now coming to another regulations, which is regulation 70, sub-regulation 3 states that in case there is a change of IRP or RP and the appointment of resolution professional is delayed, because in certain cases there may be delay of the appointment of the RP due to any unforeseen reason, then regulation 17 requires IRP to perform the functions or duties of the RP from 14th day of the insolvency commencement date. If it happens, if there is a delay in appointment of the RP, the IRP assumes the role of the RP from the 14th day. In that case, IRP shall ensure appointment of two registered valuer before the 47th day of the insolvency commencement date, because law mandates, regulation 27 mandates the appointment of the valuer has to within 7 days of the appointment of the RP, but not later than 47 days. Since the IRP assuming the role of RP after 40th day, so within 7 days from that date, the IRP who is assuming the role of the RP as mandated under regulation 17 sub-regulation 3 of the CRP regulations, he has to appoint the registered valuers, two registered valuers under each of the class. Another regulations, let us discuss regulation 35, and this regulation is the liquidation regulation. Under the liquidation process, there are separate set of regulations which governs how the liquidation process would be conducted. Regulation 35 states that where the valuation has been conducted under regulation 35 of the CRP regulation. Here both the regulations number are same under the CRP and liquidation. Regulation number 35. Under regulation 35 or regulation 34 of the fast track regulations, The liquidator shall consider the average of the estimates of the value arrived under those provisions for the purposes of valuations. Else, if the liquidator is of the view that fresh valuation is required under the circumstances, he shall within 7 days of the LCD, that is the liquidation commencement date, appoint two registered valuers under each of the class. So here the duty has been cast on the liquidator whether to consider the valuation under the CRP regulations, the value has been arrived, the same value, or he has to appoint within 7 days two registered valuers to get the valuation of the assets and in the liquidation process. Then regulation 26 of the fast track CRP regulations, which states that the resolution professional shall within 7 days of the appointment appoint one registered valuer. See, under regulation 35 or regulation 27 of the CRP and liquidation process regulations, the requirements of appointing two registered valuers are there, but under the fast track, there are only one registered valuer to be appointed who will determine the fair value and liquidation value of the corporate debtor in accordance with the regulation 34. There the regulation number 34 has been prescribed. What regulation 34 says, it states that regulation 34 of the fast track CRP regulation, it states that registered valuer appointed under regulation 26 shall submit to the resolution professional an estimate of the fair value and liquidation value in accordance with the internationally accepted valuation standard after physically verification of the inventory and fixed assets of the corporate debtor. So the essence of the valuation, the valuer has to do certain things mandatorily. One is the physical verification of the inventory, of the fixed assets, of whatever assets is there. The valuer has to physically verify whether the particular assets actually exist or not. It is not the case where the valuer can value the asset based on only on the basis of the papers, on the basis of the documents. He has to physically verify whether the inventory is there, whether the assets under valuation are actually exist or not while doing the valuation exercise. Another regulation which is there, the regulation 31B2 of the voluntary liquidation regulations, which states that the declaration of solvency given by director shall be accompanied with the valuation report issued by the registered valuer. So these are the certain enabling statutory provisions which mandates the issue of the valuation reports or the appointment of the valuer under different types of process, whether it's a voluntary liquidation process, whether it's a fast track CRP process, liquidation process, or the regular or normal corporate insolvency resolution process. All these enabling provisions has to keep in mind while appointing the valuer, or the valuer has to keep in mind the standard set of process prescribed under various regulations. Now coming to the valuations. Just a second. Valuation based on fair value. So we have prepared a brief note on this. The valuation under IBC is based on the principle of fair value. The principle of fair value ensures that the assets of the company under IBC, or you can say the distressed company, are sold at their current market price rather than at an artificially inflated or deflated price, as we discussed earlier. This ensures a fair and transparent resolution process. It shows how important valuation exercise is there, why the fair value must be adhered to. If you see the regulations 2HB of the CRP regulations, is it defines what is the fair value. The fair value as defined under regulation 2HB of the CRP regulations, it says the fair value as estimated realizable value of the assets of the CD if they were to be exchanged on the insolvency commencement date between a willing buyer and a willing seller in an arm's length transactions after proper marketing and where the parties had acted knowledgeably, prudently, and without compulsion. See, this is the an extended definition what is prescribed under the International Valuation Standard. So fair value is defined under the CRP. Let us understand each and every word which is defined here. The fair value is an estimated realizable value. The fair value is the estimate. What for what estimate? Estimation of the realizable value of the assets of the corporate debtor if they were to be exchanged on the insolvency commencement date. So what is the date which is important here? That is the insolvency commencement date. On that date, if the assets which are to be valued is exchanged between a willing buyer and a willing seller. So both buyer and seller has to be there and they are willing to exchange the assets at a arm's length transactions. So there would not be a bias transaction. It must be at a in a normal course at a arm's length basis and proper marketing after proper marketing and where the parties had acted knowledgeably, prudently, and without compulsion. So here, under the fair value, everything which is fair in a sale or purchase transactions of a particular assets is assumed that is the value arrived at that scenario is considered as the fair value. Now, the valuation based on fair value, another concept is the valuation based on the liquidation value. So we understand what is the fair value. Now we have to understand what is the liquidation value. Regulation 2 sub-regulation K of the CRP regulations defines the liquidation value as the estimated realizable value. In the fair value, there was estimated realizable value. Under the liquidation value, there is also estimated realizable value of the assets of the corporate debtor. If the difference between the fair value and liquidation value is that if the corporate debtor were to be liquidated on the insolvency commencement date. So here is certain things are missing which were existed while arriving at the fair value. What are those things? First, if you let us go back and understand estimated realizable value, the fair value is the estimated realizable value of the CD if they were to be exchanged on the insolvency commencement date between a billing buyer and billing seller in an arm's length transactions after proper marketing and where the parties had acted knowingly, prudently, and without compulsions. So all these conditions, all these features which are there under the fair value are missing under the liquidation value. You can compare fair value and liquidation value, both are the estimated realizable value of the assets, but the fair value is where there are buyers and sellers who are acting knowingly with prudence, and proper marketing period has been given, and they have exchanged the assets on the insolvency commencement date. But in the liquidation value, the liquidation value would be arrived if the value to be liquidated on the insolvency commencement date. So there is a missing essence of, there may not be buyer and seller at that date. The proper marketing period may not be given, the not on a basis of arm's length basis. So if these things are there, like this is the post sale, you can say. So in case of post sale, there is a liquidation value has to be arrived. It further says that when a corporate debtor is under liquidation, so there is another different. When a CD is under liquidation, the term liquidation value may refer to a valuation of assets when the seller is compelled to sell, wherein a reasonable period of time is given to find a purchaser less than the required marketing period. So under the, in the liquidation, there has to be a post sale, but in the CRP process, liquidation value may not be a post sale, but definitely the valuer has to assume that at that day there the possibility of selling the assets may not be there as in the fair value. So that is why fair value and liquidation value both are to be worked out, and the valuation is significantly differ between these two values. The set definition, let us further understand. The set definition in its bare reading indicates that liquidation value is the notional realizable value of the corporate debtors' assets if the corporate debtors' assets were liquidated on the insolvency commencement date, and not the value that may be realized under a resolution plan. So under the resolution plan, the fair value may be realized, but the liquidation value, that is the notional realizable value of the assets, which may not be realized under the resolution plan. Characteristically, an assets can have different values under different scenarios. So after understanding the fair value, the liquidation value, let us further understand what are the different values under different scenarios. I prepared a brief of the realizable value. So what is the realizable value? Realizable value has not been firstly defined under the IBC or its regulations. However, what is the general understanding about the realizable value is that the general understanding, value arrived after reducing the cost incurred to sell the assets from fair or liquidation value, as the case may be. So after reducing the cost of sale of that assets, it is the realizable value. This is the general understanding, although realizable value has not been defined anywhere under the IBC or its regulations. The insolvency professionals shall note that the CRP regulation mention the determination of only fair and liquidation value of the CD, whereas the liquidation regulations mention the determination of the realizable value of the assets or the business under various scenario of sale. So under the liquidation regulations, we have to determine the realizable value of the assets. It may further be noted that both fair value and liquidation value as defined under IBC mentions that it is estimated realizable value of the assets. So this gives an impression that fair value is liquidation value, which is not correct. The estimated realizable value of the assets of the CD in case of fair value is considering a willing buyer and a willing seller, and after proper marketing, which we have discussed in the previous slide, meaning giving sufficient marketing time, whereas the estimated realizable value of the assets of the CD in case of liquidation value is considering that seller is compelled to sell given a reasonable marketing time, typically less than sufficient marketing time. This premise differentiates the fair value and liquidation value. I think this is clear. Am I clear to get it explained to all of you? Uh, as of now, I
Yes,
was,
sir.
yeah, thank you so much. Any doubt or anything we have to discuss on the fair value, liquidation value among the participants? Because let us keep this session very interactive. Sir, anything you want to discuss, or shall I continue? Okay.
Uh, it's quite clear, sir, what about fair and liquidation, but I am more interested in the process an RP follows to appoint and whether he can just
I'm
appoint
coming,
and
sir.
take
Yes,
COC
sir. Yes.
approval later.
I'm coming, sir, because it's a 3 hour session, you know,
No
and
worries. Okay.
I'm coming to that. Otherwise, after completion of my session, we would have question answer session, and there we can discuss fairly in detail. No issue, sir.
Thank you so
Thank
much.
you. Yeah, yeah. Thank you. Just a minute. Now let us further move. Impartiality and independence of valuers. As you all know that valuers under IBC are independent and impartial professionals who are registered with the Insolvency and Bankruptcy Board of India. They are required to provide an unbiased and objective opinion on the value of the assets, liability, and equity. This is not to be discussed much. Now coming to the role of the resolution professional in valuation. The role of the RP in valuation process is crucial, especially in the context of the IBC proceedings. In the context of India, the term resolution professional is often used in the context of the IBC. Here is how the RP plays a role in valuation process. Appointment of valuers. First thing which my friend was asking, the resolution professional is responsible for appointing registered valuers to determine the fair value and liquidation value of the assets of the CD. This is a key step in the whole process as it helps in understanding the financial position of the company. So how the appointment takes, I have mentioned certain things here to clarify. First, identifying the types of assets and selection of the registered valuers for inviting quotations. The RP first has to consider what are the assets available under the city where the valuation is required. Under the IBC, there are three class of assets which are prescribed. One is land and building, another is plant and machinery, and third is securities and financial assets. So on the insolvency commencement, the RP before appointing a valuer has to consider, has to look into what are the assets which would be required to value. For this, he has to assess the balance sheet of the CD, financial statement of the CD, in what business CD is there, and has to divide the assets in these three typical categories of the assets: land building, plant machinery, and security and financial assets. The valuation regulations define the asset class, which I have mentioned in brief. So here, before going to appoint a valuer, ideally RP asks for the quotations from the valuers for each of the class where valuation is required under the company into the insolvency. Once the quotations are required, then quotations comes, then he has to scan the quotations. Then if there is any negotiations happens, then the valuers are appointed by the RP to issue the report. Here the problem which IP face about the budgets or the cost. See, the appointment of valuers is in the rights of the insolvency professionals, RP, but the costing part, the approval part is with the COC members. Appointment of the valuers has to be done by the RP independently. This is the essence of the code. But the RP has to get the cost or get the budget approved from the committee of creditors. So as far as costing part is there, approval from the committee of creditors is required to get by the RP. But as far as the person whom he wants to appoint has to be based on his own assessment and independence. Is it clear, sir? Now coming to the next part, supervision and coordination. The RP oversees and coordinates the valuation process. RP ensures that the valuation exercise is conducted fairly and transparently. This involves working closely with the registered valuers and providing them with necessary information and access the relevant documents. Most of the problems under the valuation assignment lies here. In the insolvency process, lack of support from the ex management, unavailability of data, information, impediment in the process step by step by the ex management. These all are the barriers in fair and transparent, or you can say the orderly conduct of the valuation exercise, because all the exercise is based on the information documents and the RP is not having the same. How the valuation can be exercised in a very fairly manner. Let us take an example. Let us take an example of the plant and machinery first. RP has to provide the list of the plant and machinery based on the list of assets. But in maximum cases, the information documents are not provided by the ex management to the RP. RP do not have the ready available documents. Then what he has to do, he has to himself take the list of the machinery and plants available. And the list is given by the RP to the valuers who is supposed to conduct the valuation and the plant, valuation of the plant and machinery. Valuer physically visits the premises where the plant and machinery are there. In some cases, there are not a mark on the machine how old it is. There is no invoices. There is no value as such. So considering all these problems and limitations, how the value can be arrived a fair value. The valuation can be effective only if there are proper data available with the RP, and the data has to be given by the X management or from the other sources where it is where he can get. Only then the fair valuation can be arrived. And this is the example of the plant and machinery, but this is almost same in all the cases, whether it's a valuation under land and building and security and financial assets. Under the land and building, there are certain uh, things where the value can be arrived at a fair market value based on the transactions done nearby area. So, I mean to say the data is the essence. The RP has to endeavor to get maximum data from it. Then he has to coordinate with the valuers. RP himself has to indulge in the valuation process with the valuers to identify the asset where it is, how the assets, in what conditions the assets are lying. So these are the supervision and coordinations which RP and valuer has to work closely to get the maximum output in the valuation report to ascertain the correct value, fair value, and liquidation value. These are the essence of this IBC process. Now coming to the ensuring compliance. The RP ensures that valuation process complies with applicable laws and regulations. This includes adherence to the guidelines and standards set by IBPI for conduct of valuation. So these are very compliances, very procedures which RP has to ensure. Valuer also has to ensure, like taking the disclosures, whether they are independent or not, whether the persons acting with them, whether the various stakeholders involved in this process, are they are they interested parties, or they have any financial interest or not. So all these disclosures has to be there, and the RP and the valuers has to ensure that they are conducting the valuation. The RP is appointing the valuer as per the set procedures established by the IBPI in conducting the valuation exercise. Then verification and review. The RP is responsible for verifying the accuracy and reasonableness of the valuation report. This is after getting the valuation report. So first the appointment is there, then supervision and coordination, then make all the compliances, making available the data, then physically verification of the assets by the valuers, then issue of the report after whatever observations are there and the exchange of informations, then valuation report is issued. So the RP has to verify whether the valuation reports are accurate and reasonable, which is submitted by the registered valuers. They may engage with the valuers to seek clarifications or additional information to ensure the comprehensive understanding of the valuation result. Here, RP has to work closely with the RVs, with the valuers, whether the report submitted by them is devoid of any merits, whether all the information which are given or the assets which are to be considered are there in the valuation report. whether the fair value and liquidation value are correct or not, considering the nature of the CD. So all these verifications and review work has to very has to be ensured by the RP. Then communication with the stakeholders. The RP communicate the results of the valuation with the, just a second, committee of creditors and other stakeholders. The valuation outcomes are critical in decision-making process of the COC, especially when considering the resolution plan or deciding on the liquidation of CD. So, after getting the report and as per the set procedures, after getting the resolution plan, the valuation information and reports are shared by the RP to the COC members after getting the non-disclosure agreement and all. This valuation reports plays a crucial part in decision-making process, and the COC, based on the valuation outcome, decide what to do in the particular case, whether the resolution plan to be approved based on the valuation, or the CD would go into the liquidation. So these all are the basic things which are there under the IBC regarding the valuation. Now moving forward to the documentation part. The RP maintains proper documentation of the valuation process. See, the documentation part is very important because as per the code of conduct, RP has to maintain proper documentation. He has to keep the records for certain period of time, including the engagement with the valuers, information provided, and the valuation report. So the entire process documents RP has to maintain since the appointment of the valuer, sharing of the informations, letter of engagement or appointment letter, disclosures, what informations have been provided by RP, what additional information were asked by the valuers from the RP, then what information provided. So all the chains of process, all the chains of documentation has to be kept by the RP, and the valuation reports also, the review, any corrections, any additional things. So the entire flow of work documented by the RP. This documentation is very important for what? For the transparency, and can be subject to scrutiny during insolvency process, even thereafter. So RP has to document everything. Even registered valuer who is conducting the valuation exercise has also to do the proper documentation because he is also subject to inspection by the IBPI. Whether he has physically verified the assets or not, everything, I mean, has to be documented by the RP as well as the registered valuer here, because he is also a governed professional by the IBPI. He's been licensed, he's been given the registration by the IBPI. Then supporting decision making. Here the valuation report prepared under the guidance of the RP are essential for the COC to make informed decisions regarding the future course of action, such as accepting or rejecting resolution plan or opting for liquidation. We have in detail discussed what is the fair value, what is the liquidation value. So the valuation report mention the fair value and liquidation value of the assets of the corporate debtor. What resolution plan has been submitted by the RA, what the value is there in that plan, that all has to be considered based on the comparison, and the comparison is from the valuation report. The valuation report must be accurate, fair, It must not be overvalued, undervalued. And it is assumed that the RP has worked closely with the valuers to get the accurate value of the CD, so that the proper decision, the informed decision, the appropriate decision is taken by the committee of creditors to decide whether the particular plan has to be accepted, or the company is better to get into the liquidation and face the maximum realizable value from the liquidation process, as the value of the resolution plan may not be proper. And further, to negotiate with the RP, with the RA, if the resolution plan is not to the expectation which is based on the valuation exercise or valuation report, the price given by the valuers. So decision making process is very well supported based on the valuation reports. Now coming to the challenging valuations. In certain cases, the RP may challenge the valuation if they believe there are errors or discrepancy. This is done to ensure that the valuation is fair and accurately reflects the financial position of the corporate. So this is not after getting the valuation. This should be before getting the valuation. And since the RP is expected to work closely with the valuers, this type of things which can be taken care of before getting the final valuation reports. So in summary, let us see the resolution professional plays a pivotal role in managing the valuation process within the framework of insolvency and bankruptcy proceedings. Their responsibilities include overseeing the appointment of the valuers, ensuring
Excuse me, sir.
compliance. Yes, sir.
If you like, you can take break.
After 2 minutes, I will be taking break.
Okay, sir. Okay.
After 2 minutes, just finish this slide, then I will be taking the break. So, overseeing the appointment, ensuring compliance, reviewing the verifying valuation reports, and all. The objective is to achieve a fair and transparent valuation that contributes to the resolution or liquidation of the CD. Now, let us take some break as suggested by our colleague. Then, after 50 minutes, we can assemble.
You said
Is it
10
fine?
minutes or 15 minutes? Sorry.
Sir, it will
Whatever
be
it
a
is.
10 minutes break.
It's a 10 minutes, so fine. After
Thank
10
you.
minutes, we will. Thank you so much. Thank you.
up to the date of a CRP commencement from 2013 to 2019. And well, in this case, it's mostly home buyers. There's enough documentation available as to what they paid or did not pay. But in other assignments where I was valuer, it's always a job getting the financial as on date of incorporation commencement. You have to work with the RP, convince them that, look, if the date is, let us say, 31st July, you have to give me accounts as on that date. And make that a condition before they even accepting the appointment. Once you get that, obviously you can't go by what is there. I mean, as a job of us to go and tell them that you have to get us confirmation from or other evidence as far as debtors is concerned from the party, and appropriately value them.
Hello. Sir, RP appoints two valuers. If any significant difference between the two valuers, he will appoint the third valuer. How can challenge the valuation? How can RP challenge the valuation? In what way?
Sorry, how can RP?
RP challenging the valuation. How can they challenge the valuation?
No. Actually, the thing is this: there are certain cases where the RP has changed. The valuation taken by the previous RP, right?
Yeah.
So what I suggested that there must not be any challenge.
No, sir,
all thing has to be ascertained before getting the final report.
Okay. You have said the challenging the valuation. In what way? In what manner he will challenge the valuation? Suppose if the previous valuation also, previous value also appointed by the RP only. If there is any significant difference between the two valuers, he will appoint a third valuer.
Correct. Is correct. But this significant valuations and all has come later now. It was not earlier. So earlier if you are engaged in this process earlier, then somebody was talking about more than 10% difference is a significant difference. More than 20% difference is a significant difference. There was no ascertainment of the significance. The word significant was not defined earlier. It is not defined, firstly. Secondly, suppose if you are getting information later point of time after getting the valuation, then you have to request the valuer that these are the certain informations which I have received later. Then you please issue the addendum or the revised report or the supplement report on the basis of that. So these are comes under the challenge. So it is not that we are challenging my
exactly
report.
Challenge. That's what.
It's not. So you can say the supplementary report or whatever it is. Otherwise, this will be very, odd situation because you are challenging your own report.
Thank you, sir.
Very correctly pointed out, sir. So, yes, sir. Any other participants' experience, please? Because we are facing the challenges in all our assignments day-to-day basis from one or other corner. So it would be better if we share our experience, then we will further delve into the valuation exercise. Yes, sir. What about the debtors? Because in most of the cases, let me share my experience where I am acting as a valuer or even the IP. So as I shared that we have the data of 2018. And suppose we are appointed the valuer as of now in 2024. Say there are thousands of crores of debtors as per the books of accounts and the books of 2018, 31st March 2018, the final data was there. After that, there is no records available. So if this is the case, the 1,000 crores of debtors are there, and you are valuing the security and financial assets as a valuer, how you would value the debtors? What is your experience? What is your suggestions in this type of valuing particular debtor? So my specific, curiosity to know from you people, how are you going forward in these cases. I've given you the exact scenario. Yes, sir. What would be the proper, what would be the accurate value so that we can find the fair and liquidation value of that particular uh, segment of the SFA value? Any idea or any note by you? Yes, sir, please tell me how you will value in that case, or how you will assess the valuers and getting the value assignment. Suppose the valuer gives you the value of 1000 crore. He says, okay, I am roughly estimating 10% of the value which are there in the books. So I am giving that value. Will that be okay? Will that be acceptable? Any idea? Any clue? And your take on this as a RP? No. To me, sir, let me tell you. See, as we discussed that as a valuer, we have to arrive the accurate value, the value which one has to, what is realizable value. So we have to see whether the value as on valuation date, that is the CRP commencement date, is realizable or not. Since we have been given the figure, not the data, of 2018, whatever amount it is, I have roughly estimated the amount, whatever it is. And as on date, we have to see whether is there any amount which can be realized. For that, we have to see the aging schedule, how long, how old the debtors are, what are the addresses available with us, whether we can really go to the court to get the debtor realized, because there is limitation period also in this case. After 3 years, you cannot take the recovery. So all these things has to keep in mind while valuing the particular piece of asset, that is the debtor. So in 2018, the valuation, the figures are there in the balance sheet, but there is no data, there is no addresses, there is no balance confirmation. I used to take the value at zero value because it is not realizable at any paisa. So I'm sharing my experience. So this is all happening here. In absence of data, this is really very tough to get the accurate value. Fine. So now let us come to our I am sharing the CRP regulations before going further. This is the recently amended. Just a minute. This one. Regulation 35 of the CRP regulation. Subclause A. This one. The fair value and liquidation value shall be determined in the following manner. As we discussed earlier, that the two registered valuers appointed under Regulation 27 shall submit to the resolution professor an estimate of the fair value and liquidation value computed in accordance with the internationally accepted valuation standards after physically verification of the inventory and fixed assets of the CD. So earlier, what you can say that there were some practices prevalent that the valuers in some cases escape to physically visit the premises of the CD and issue the valuation based on certain his understanding or whatever it is. So this regulation clearly mandates that after physically verification of the inventory and fixed assets. So if there is any inventory, the inventory has to be physically verified, and also the fixed asset, they are physically to be verified before arriving any estimate of the fair and liquidation value. Further, in the recently amendment, it's through a proviso, it added that the resolution professional shall facilitate a meeting wherein registered valuers shall explain methodology being adopted to arrive at valuation to the members of the committee before computation of estimates. So let us especially discuss this proviso, which mandates, because the word used is shall, the RP shall facilitate a meeting wherein registered valuers shall explain the methodology. What registered valuers shall explain? The methodology being adopted to arrive at valuation to the members of the COC before computation of the estimate. So keeping in mind this particular amendment, this was added in on 15th of Feb 2024. This amendment was added. So here, what is the practice being adopted as per in compliance of this regulation is that before the valuer gives his valuation report or arrives his estimate, the meeting is arranged by the RP with the COC, where the valuers are invited, all the three class of valuers are invited to explain that what are the methodology which are being used to arrive at the value. And if there is something which the COC wants to communicate or the RP want to communicate or have the clarification from the registered valuer, then that is happened in the COC meetings also. So anyone having the experience about this meeting as a valuer or an RP, let us discuss that also. Yes, please. Anyone? Anyone as RP or as valuer who have invited or who have given the presentation on the methodology before the COC? Let us enrich with the knowledge of that particular fellow. Yes, sir. No, sir. What shall I assume then? Nobody has presented methodology as RP or as valuer. I want to
You see,
understand. Yes.
in my case, when I appointed, I took some key members of the COC. I took them on a call. And but at that time, this regulation was not there because this was in 2020.
Yes, on 15th Feb 2024. Yes, sir.
So
yes,
I
Mr.
have not
Lalit. Yes, Mr. Lalit, you are mute. I think you want to say something. Mr. Lalit, you want to say something? You are mute. Kindly unmute yourself. सर काइंडली अनम्यूट मिस्टर ललित आप कुछ कह रहे हैं बट आवाज नहीं आ रही आपकी ओके इट्स फाइन नो इशू सो I as a valuer was given the opportunity to present the methodology before the COC members to to explain them what methodology I have used while arriving at the value. So there I have prepared a brief note on the each and every class of assets. I have not shared the value over there. Now, what valuer has to keep in mind, he has not to share the value if the undertaking is not been given by the members, because the regulation says that before computing of estimates, the valuer shall explain the methodology being adopted to arrive at valuation to the members of the committee before computation of the estimates. He has to explain what methodology he has used to arrive at the valuation. Suppose, let us take an example of the debtors which we have taken. That I have to explain this. You see that there are certain debtors in the company, and what are the approaches in the valuation which you have adopted, and what are the methodology you have adopted in computing the estimate. So that all has to explain by me to the committee of creditors. But we have to ensure that we are not disclosing the value of the asset which is arrived. What we are supposed to explain only the methodology what you have used. That's it. So that part is there added recently by way of an amendment in the valuation regulations. So this is what I wanted to discuss with you. And under the regulations, okay. Now let us come to my presentation part. So I was here, right? So in summary, the resolution professional plays a pivotal role in managing the valuation process within the framework of insolvency and bankruptcy proceedings. And the responsibilities includes overseeing the appointment of the valuers. We have to ensure the appointment has been strictly done as per the established and laid down procedures by the IBBI under various regulations and IBC code. Ensuring compliance, we have to ensure that the appointment is done within the time frame, valuation exercise has been done in strictly compliance of the provisions. Reviewing and verifying valuation reports, that on getting the reports, we have to verify it, we have to review it, whether the entire assets have been valued, there is no misinformation or wrong information. If it is so, then we have to coordinate and get the revised report at that time before getting the final report. Then facilitating communication with the stakeholders. On getting the report as per the provisions, we have to communicate the outcome of the valuation reports at a given or at a standard time frame. The objective is to achieve a fair and transparent valuation that contributes to the resolution or liquidation of the corporate debtor in a way that maximize value of the creditor. See, there is only objective of this valuation to get fair and transparent valuation so that the committee of creditors can take the informed decisions of for the purpose of getting the value maximization of the CD, whether the company to be resolved as per the plans in hand and to get the company liquidate if the appropriate value is not being fetched during the CRP process. So this is the objective of the valuation. Now let us dealt with some case law. I have one or two case law. One is State Bank of India versus PPS Enviro Power Private Limited. So the brief of the case has been mentioned here. So for the understanding of the learned participants, let us understand what happened in this case and what was the outcome. So in this State Bank of India versus PPS Enviro Private Limited, this is a recent case, not a very old case. In this case, application was filed by Suspended Board of Corporate Debtor, that is PPS Enviro, under section 60 subsection 5 of the IBC. You know, the section 60 subsection 5 is a section which empowers the NCLT or the adjudicating authority to exercise power under the IBC to decide any matter, seeking an order to set aside the impugned e-auction dated so and so by the liquidator and call for a revaluation of the assets, especially lot 3. So there was some asset, lot 3 asset was there, which was sold out by the liquidator. The corporate debtors ex management filed an applications under section 60 subsection 5 praying the adjudicating authority to cancel the e-auction which was conducted on certain dates. The applicant, who is the director of the suspended board, had assailed the e-auction sale of the corporate debtor as a going concern held on so and so date on the ground that the ground was the valuation of the properties got done by the liquidator is incorrect and does not reflect the true value of the realizable value of the said property that would fetch in public auction, hence prayed the Honorable Tribunal to set aside the impugned sale. So here the e-auction was conducted, it was successful, the suspended managements approached the court to get the entire e-auction sale set aside. And in support of his plea, it was contended by the Council of the Management that 34 windmill site with a land area of 71,275 acres and 33 windmills with a capacity of 33.125 megawatt, including contingent liability and secured financial assets, capped a reserve price of rupees 59.88 crore, whereas today's cost for installing wind power per megawatt is around 7 crore per megawatt. So in this case, what happened that the auction sale was conducted and the assets which is mentioned here was sold out. The reserve price of the assets was kept as 59.88 crores. But the contention of the ex-management was that for 1 megawatt installation, there is 7 crore rupees per megawatt cost is there. And 33.125 megawatt capacity was sold out just for a reserve price of 59.88 crore. So this is the reserve price. It is not whether sold out or not. So this will be understood in the latter part. And the same makes the total value around 230 crore. And even on taking 50% appreciation and stress due to pending litigation, these assets shall fetch around 150 crore. Hence, the liquidation value as arrived at is grossly low. So, in every case where the liquidator sells the assets, management always dispute that, see, you have sold the assets at a very meager price. You have not conducted the valuation very correctly. The valuers are not performing their duties. It is always challengeable by this suspended board. In this case as well, in this PPS and Viro case, the case was filed before the NCLT. What happened? Let us see. The liquidator submits. What is the contention of the liquidation in this case? The liquidator submitted that fresh valuation of the CD assets was done as per regulation 35 of the IBBI liquidation process regulations. So here the court usually see what the RP or liquidator did while getting the valuation, whether the procedures has been completed, whether the procedures has been followed strictly as per the procedures laid down by the statute. So here the contention of the liquidator was that the fresh valuation of the CD assets was conducted well within the regulation 35, and the assets, and with respect to the following assets, as felt that the first valuation was got done in December 2020 during CRP, and windmills were located in open wind farms and were non-functional for more than 2 years, exposed to weather condition with likely erosion in the value. See, the valuation during the CRP was got done in December 2020 in that case, and the liquidator get the fresh valuation after 2 years, considering certain erosion in the value of those. So this was the contention of the liquidator before the Honorable NCLT. The liquidator alleges that the applicant had approached this Honorable Tribunal with unclean hands and is trying to scuttle and frustrate the liquidation process by intervening and seeking revaluation on so and so date, means the current date, on the date when second e-auction was held and the e-auction was successful, thus submitting prayed the tribunal to dismiss the application. See, from both the counters, the argument and counter arguments was there. So the issue whether the e-auction held on 21st June 2023 can be set aside on the grounds pleaded in the applicant, or the contention of the liquidator shall be subsist. This is the issue before the Honorable Bench. So in this case, what was the court observation? This is very important for all of us. The Honorable Tribunal, having heard the learned counsel for both sides and on perusal of the record, it is to be stated that the procedure contemplated under the IBC and the relevant IBBI regulations has been duly followed by the liquidator. So as an IP, what we have to keep in mind that whatever procedures in respect of valuation has been prescribed is completely followed or not. If it is followed completely in strict letter and spirit, then then the IP may not, or the IP, there are 100% chances that IP will not be held negligible by the bench, by the honorable NCLT. And in this case also the NCLT held that the procedure was completely followed by the liquidator. The registered valuers of all three asset classes have submitted their reports with fair value and liquidation value of the assets on as is where is basis. The valuers have submitted the reports as is where is basis. The land and buildings, plant and machinery, and security or financial assets were valued separately. So the court has observed that the valuer has valued all three classes of assets separately. Thereafter, the stakeholder consultation committee, in its fifth very meeting, having taken into account considering the liquidation value of 72.24 crore, decided to fix the reserve price for sale as a going concern with 69.14% votes. So here the entire process was followed by the liquidator. The stakeholder consultation committee, where the reserve price, where the liquidation value was 72.24%, it fixed after considering the going concern and all with 69.14% vote, the value of 59 point something, this value. $59.88 crore. So this value was fixed. Therefore, the plea of the applicant, that is suspended management, as per the valuation done by the valuer chosen by him, a higher valuation was shown in the absence of any scientific and acceptable basis for such valuation cannot be a ground to reject the valuation that has been arrived based on the report submitted by the empaneled valuers of the IBBI. In this regard, it is pertinent to state that valuation report that the applicant is relying on were admittedly prepared without conducting and physical inspection of the windmill, since no permission was either sought or given by the liquidator to purported valuers for physical inspection of the windmill which are under the lock and give liquidator. Therefore, no reliance can be placed on these reports. So all these pleadings were not accepted by the Honorable Tribunal, which was contemplated by the Council of the Suspended Management. Therefore, viewed from any angle, the Honorable Court held that application of the suspended management is devoid of any merit or substance and appears to have filed only to stall the sale of the corporate debtor as going concern without any bona fide. So in this case, one can very well understand that if the procedures is followed, there may not be any problem on the part of the liquidator and valuer, even it is challenged before the higher court, whatever court it is there. Let us now discuss another case. The other case which I have selected, that is the Jaipur Sugar Company Limited versus IDBI Bank Limited. In this case, the application was preferred by the secured creditor in relation to the corporate debtor under same section 60 subsection 5 of the IBC. One may consider that in the earlier case, the application was filed by the suspended management, but in this case, the application was preferred by the secured creditor. And following reliefs were sought. First, direct the liquidator to take necessary steps and include as part of the liquidation estate of the CD, the property and assets of the CD and accordingly update the asset memorandum as per regulation 34 of the IBBI liquidation process regulation. And the second prayer, second relief, which was sought by the secured financial creditor, was to set aside the valuation conducted as it is not in compliance with regulation 35 of the liquidation process regulations. Let us see what happened in this case and what were the facts. The learned senior counsel for the appellant averred that the liquidator has adopted an irregular procedure for obtaining the valuation of the assets of the corporate debtor and also excluded certain assets of the CD from the liquidation state, which resulted in non-maximization of the value of the assets of the corporate debtor. So here the procedure was challenged by the secured financial creditors, and it was contended that the valuation conducted was not in compliance with the regulation 35 of the liquidation process regulations. It was further submitted by the counsel of the secured creditor that how the revised valuation, which was conducted by the registered valuers, that is, the name of the valuers was also there, that Mr. Santa Kumar and Mr. R. Chandran, who were appointed by the liquidator on the assets of the corporator, are not by the procedure established under regulation 35(3) of the IBBI liquidation process regulations, which stipulates that the valuation of the CD shall be conducted by two registered valuers who shall conduct their valuation independently on the entire assets of the CD, and that the average of the two estimates received shall be taken as the value of the assets of the business of the CD. However, it was submitted that although the valuation of the assets of the CD was conducted by two registered valuers, the valuation was conducted separately on the plant and machinery by one registered valuer, Mr. Santa Kumar, and on the land and building by Mr. R. Chandran. Instead of same being conducted holistically on the entire assets of the corporate debtor, hence it was submitted that the revised valuation is in clear contravention of the procedure established under the code. Now the issue which was there before the bench was whether the assets of the CD at Rayagada, Odisha would form part of the liquidation state of the corporate debtor, and if so, whether ascribing valuation as zero on account of pending litigation for the sold property is right. So this was the issue before the bench, and the averments made by the secured financial creditors were also there. So now let us see what happened further. Another issue was whether the decline in the valuation of the corporate debtor during the liquidation process adequately addressed by the corporate so observation of the code. Let us come to the observation. The valuer ascribing the value at zero in respect of certain property on the ground that the sold property in under litigation has been done in total disregard of section 36 subsection 3E of the IBC, which clearly manifests that these assets which are subject to determination of ownership by the court or authority would form part of the liquidation state. It is seen from the documents filed along with the typed set that the valuers have not examined the nature of litigation and also failed to examine whether such litigation is relating to determination of ownership in respect of the corporate debt. So this is the observation of the court in this case, that whatever the property was under litigation, it has not been determined. No documents has been examined, and the nature of litigation has also not been examined by the valuer in determining the ownership. It is required to be borne in mind that the valuation of the assets of the CD is different from the issue whether corporate debtor has marketable title over the property. Simply because the corporate debtor has no marketable title over the property does not make the value of the property as zero. So here the court clearly observed that the marketable title cannot be a ground for assigning the value of the particular assets at zero. Further, the liquidator who is holding the liquidation estate in a fiduciary capacity for the benefit of the stakeholders is required to examine first as to what are the property which are forming part of the liquidation estate. The valuation of the property has to be done by the registered valuer by keeping into consideration the parameters as set forth in section 36(3) of the IBC. So here the certain issues were there. Let us summarize. Firstly, the asset memorandum which is required to be prepared by the liquidator is a very crucial document as well, where he has to mention what are the assets which are to be liquidated, the estimated value of the asset which are there in the asset memorandum. Here, in this case, certain parcel of property where the marketable title was not there with the CD was assigned the zero value by the liquidator. The court observed, the bench observed that it is not the right approach on the part of the liquidator. The liquidator is holding the liquidation estate in a fiduciary capacity and for the benefit of the stakeholder. And he has to be very cautious. He has to examine all the property, what are they, whether they are forming, they can be form part of the liquidation estate or not. This all has to be done by the liquidator. Then the registered valuer has to value the assets based on the information, based on the mandate given by the IP to the valuer. Then the second issue which is required to be adjudicated before this tribunal was that, just a second please, whether the valuation of the corporate debtor during the liquidation process has been done in accordance with the regulations framed under IBPI regulation by the liquidator, and also whether the reasons for decline in the valuation has been adequately addressed. Regulation 35 is a very important regulation which prescribes almost the entire process, which deals with the valuation of the assets of the corporate debtor intended to be sold. And what is the regulation? It is seen that the liquidator has not adopted the value that have been arrived at during CRP process. CRP period valuation was not considered by the, was not arrived by the liquidator. And as per regulation, sub-regulation 2 of the regulation 35 of the IBBI liquidation process regulation, liquidator ordered a fresh valuation. Here, please note that the liquidator ordered a fresh valuation of the assets of the CD. However, I have underlined this. It is a fact that is borne on the record that liquidation value has been arrived at only by one set of valuers and the liquidator has not obtained valuation from the second set of valuers to obtain a mean value. So here in this case, what has done, what the liquidator did, that he has appointed two valuer, but for each class there was not two valuers, there were only two valuers. So uh, one set of valuers valued one class of assets, and another valuer valued the other class of assets. It is also seen that the liquidator has ordered a fresh valuation after the filing of the present application. Surprisingly, the court observed that the valuation was conducted after filing of this application. It is also seen filing the application, which facts itself shows that the liquidator has not acted under regulation 35 subsection 2 of the IBBI Liquidation Process Regulation 2016, which says that the liquidator shall within 7 days of the liquidation commencement date appoints two registered valuers to determine the realizable value of the assets. If the liquidator had appointed the second set of valuers simultaneously by Regulation 35, Subregulation 2 of the LP regulations, and also as per the request of the stakeholder, the issue in respect of decline in the value to the tune of 100 crore would have been averted. Further, it is also seen that liquidator has also brushed aside the request of the stakeholders to order for a fresh set of valuations without assigning any regions whatsoever. So court in this matter, in this case, has gone into the detail of the entire process which is followed by the liquidator when he has issued the mandate for valuation, when the valuer were appointed, what are the value the valuer has considered, the liquidator has considered, and how many valuers were appointed for each class of the asset. The entire process were inquired by the honorable bench, and after looking the entire things, the court observed in this matter the liquidator that he has not performed the duties in respect of valuation properly as per the specified procedures. So this was happened in this case. So we have two cases for understanding. One, State Bank of India versus PPS Enviro Private Limited, where the court, after going into the details, ordered that the liquidator has followed the procedures entirely. And in the another case, in Jaipur Sugar Company Limited, where the court ordered that the procedures were not followed by the liquidator and accordingly decided the matters. Now coming to the benefits of the unique valuation features under the IBC. So this is for the sake of brevity only. Now, what are the benefits of the valuation? That enhancing transparency in the insolvency proceedings. The valuation under the IBC ensures transparency and fairness in the legal process by providing a clear and objective assessment of the value of the distressed company. See, the set of procedures prescribed under the IBC are comprehensive, and it is aimed at to provide the fair and transparent proceedings as far as valuation and as far as the IBC is directly concerned. So transparency is at the top. The safeguarding the interest of the stakeholders, the another feature. Valuation under the IBC helps in safeguarding the interest of all stakeholders by ensuring that the distressed company is sold at a fair price, thereby maximizing the value of the assets. So if the assets are getting properly valued, then the value of the assets maximized, and all the stakeholders will be benefited from this exercise, valuation exercise. Then facilitating fair and equitable resolution plan. So this is the essence of the valuation. Valuation under IBC helps in developing fair and equitable resolution plans that benefit all stakeholders and ensures a smooth transition from the distress company for a distress company. Suppose the valuation is not appropriate, then really the fate of the corporate debtor may not be good and it will go into the liquidation. So valuer has to arrive the value very properly. Now, what are the challenges in implementing unique valuation features under the IBC? First, availability of the qualified valuers. Recruiting qualified and experienced valuers remains a major challenge in the implementation of the valuation under the IBC. See, we invite as a IP, we invite the courts, we invite the profiles of the valuers to be appointed in particular case. We have certain limitations regarding we do not find the qualified valuers who are really very, experienced. They are doing the assignment in a holistic way. So there are certain challenges that availability of the qualified valuers are not here. Second, data availability and accuracy, which we have already dealt into, that the availability of data and accuracy of the data is a major challenge. As we discussed, the IP do not get the proper data from the X management. They do not get the information. There are challenges. So in absence of data, the valuation may not be as good as it should be. The potential conflict of interest. The other limitations, challenges, that conflict of interest can arise in the appointment of the valuers and may compromise the fairness and objectivity of the valuation process. We have seen in some of the matters that even the COC members suggest us that appoint this one from the panel of the banks. So these all are the challenges which we are facing regarding the conflict of interest. Now, let us not go into detail in this. Yes. Conclusion. Valuation under IBC is a key component in ensuring a transparent and fair insolvency resolution process. It helps to safeguard the interests of the stakeholders and facilitate fair and equitable resolution plans. So this is the conclusion why this valuation under IBC is key component. Effective implementation of the unique valuation features under the IBC is essential to ensure the success of the IBC, of the process resolution plan, and to maximize the value of the distressed company. And in conclusion, the valuation process under the IBC exhibits unique features that distinguishes it from conventional valuation practice. So the entire valuation exercise under the IBC has introduced a comprehensive framework, and the aim of introducing all these comprehensive framework under the IBC to resolve the insolvency issues effectively, efficiently, in order to maximize the value for the creators. In essence, the unique features of valuation under the IBC reflects a paradigm shift towards a more dynamic, market-oriented, and time-efficient approach to resolve insolvency. The emphasis on the transparency, professional expertise, and structured framework position the IBC as a comprehensive and effective tool for addressing corporate insolvency challenges in the Indian context. So this IBC has laid down the comprehensive framework where the duties and the responsibilities of each and every stakeholder is prescribed, be it a resolution professional, liquidator, valuer, even the how this, what are the powers of the COC, what are the powers of the RP in respect of the valuations, that all has to be taken care by each stakeholders in this process. So now let us come to the another part. This is VRN, valuation reference number. Any idea about this? Yes, sir. I was speaking since long, so let us have some discussion on this. VRN, this is recently introduced. Yes, sir.
Well, it's definitely good.
Have you, sir, generated any VRN for your assignment?
I have not, because what I've been doing is more related to SEBI related,
Okay.
valuations of alternative investment funds portfolio, where this is not
Okay.
required, at least for the
Okay.
valuation, that is ICMA, where I'm registered. But
Okay.
I had one doubt here. Assuming you do the VRN, you sign, and as it so happens, they come back to you and ask for a change. In my case, it was there's something called under SEBI, alternative investment funds. You have to give valuation reports based on audited accounts, and audited accounts were not there. And subsequently, audited accounts were made available to me, and they asked, "Why don't you change this to say that they include this?" I was just wondering whether you go back and get one more VRN, in such a case.
Yeah. Very true. So as far as my understanding is there, let me share you that as a valuer, you have to, generate the VRN for the valuation report you issue. So when you generate the VRN, that is for the CRP process. Basically, we are talking about this VRN. This is for the CRP process because
Only for
when you
CRP
log
process. Yes.
CRP or liquidation process, whatever it is.
Yeah.
So when you log in as a registered valuer, you will have to punch the name of the corporate debtor.
Right.
It will automatically come when you when you fill the name of the or you punch the name of the corporate debtor. The corporate debtor list of the list of the cases where insolvency is going on will be there. You have to select that corporate debtor where you have appointed as a valuer. Correct, sir?
Yes.
Then the date would be for the today's date. There cannot be backdating.
Right.
So earlier what happened, that valuer issue the valuation report, and suppose it is 23rd today, and I want to issue the valuation report on 15th of this month.
Yes.
This was possible earlier, but today it is not possible.
Correct.
So it cannot happen. So this VRN will be generated, and once you submit, your VRN number automatically generated. Now your question whether we can regenerate, we can amend or we can regenerate. So although I'm not gone into the regeneration, but yesterday was trying to generate the report of one of the client. There was some system error. So I submitted I don't know when it was generated. It was generated. Then I again trying to generate, the pop-up was there. VRN already generated.
Okay.
So considering that scenario, I assume that for that very VRN, you cannot generate the fresh VRN.
Hmm.
But I don't know whether it was the case for yesterday. If I will try to generate for today's also, if there is any something, na? Because on the same date it may not be taking, but for the subsequent date it may be taking revised report. Because earlier we used to issue the revised report, supplementary report, when we got some data later on. So let me check it, sir. I am not very sure about this VRN, whether it can be amended or not.
Yeah, for example, even IBBI, though are not going to allows us to revise a form once we submit. And even in this case, I assume that, okay, this is very early days, but there should be some scope for revising something.
Sir, I think because I have tried yesterday only. So
Okay.
I think if I generate the VRN for the same corporate data on the subsequent date,
Yes.
there may be possibility, what I feel.
Yeah, no, I think so. I'm only talking about a subsequent date.
Yeah. So there may be possibility, and in that case you can revise the report.
Right.
Otherwise, issuing a report by you on some particular date, you cannot. I understand that you cannot generate the VRN on the same date, but you can generate on the next date, may be possible. So, but I have to check. I'm not very sure, sir.
Thank you so much.
Yeah.
Sir, can I ask a question?
Yes, please, sir.
It is related to Mr. Amrender, what Shiv Kumar said. But in my case, I am RP. So normally at the commencement of CRP, audited balance sheet is not available. So we give the draft balance sheet to the valuers. And based on that, all the information, whatever they ask, we give. And they give the report. And it is presented to COC, it is acceptable also. Later on, when we are finalizing the audited balance sheet, so then there will be naturally some differences between the draft balance sheet and audited balance sheet. So is it our duty to inform valuers, and up to what time?
Sir, anytime when you are access certain additional data, anytime, and you have put up those data or you have communicated those data to the COC member, and if COC decides that yes, this is very relevant portion of the data which to be incorporated in the valuation report, you can request the valuer to get the supplementary or the revised report issued at a later point of time based on the certain information you have received later on. So this is, you can, ask anytime, sir. There is no restriction on it.
You mean to say that we should take COC into confidence?
Definitely, sir. Because as an IP, every IP has to take COC or SCC into the confidence before doing any additional thing, which were already there into their knowledge, and you are doing certain things which affect the decision making of the COC earlier. So you have to take the confidence into the confidence, to my view.
Okay.
Yes, sir.
Thank you.
Yes, sir. Welcome, sir. So this is VRN. Earlier, what is the essence of implementing this valuation reference? See, as a practicing valuer, you know, every institute where you are practicing issue the COP, and UID is being mandated on every professional, whosoever, whether a chartered accountant, company secretary, or cost accountant. But in this valuation exercise, there was no compulsion as such unique identification number. So to overcome that limitations, the IBBI recently has introduced this VRN number, and this is a very good concept. The unique feature is this: you cannot generate the VRN on a back date. This is the unique feature which is nowhere. Because if you are a chartered accountant and you have to issue the UID number, UIDN, then that 60 days, I think, time frame is there. Within 60 days, you can generate the UID, but here in case of valuation, there is no such post effect. You have to generate the VRN on the same day when you are issuing the valuation report. And you have to mention this VRN number on the top of the page. The circular number is there. You can go through and accordingly act, whether you are issuing the valuation report or you are getting the valuation report, whether it is compliance of the circular or not. As a IP also, you have to ensure whether you are getting the report which with the proper VRN number. This is regarding this VRN. Now, sir, coming to the certain valuation process, this is certain headings which I have taken from the IIPA draft paper on the valuation process. So I would recommend each and every professional to go through this draft paper. Complete information about the valuation exercise. I will not go into detail on this. I am just putting this headings, that is regarding appointment of the valuers. Everything is there, including the statutory information and all. Information sharing with the valuers. What are the information which IP must share with the valuer? That is also there in detail. Carrying out valuation process. What are the process? How the valuation reports? What is the format and all approaches, methodology and all, that is detailedly covered in this valuation paper, draft valuation process. So determination of the valuation parameters, methods. I will not go into the details. I am just giving a view of the types of approaches in the valuation. Any valuer who is issuing the valuation report has to follow certain approach, and these are approaches as per the international valuation standards. So there are basically three types of approach. One is the market approach, another is the income approach, and third one is the cost approach. So under each of the approach, there are the methodology which the valuer has to follow. Like under the market approach, the comparable transactions multiple methods, commonly known as CTM method. Another methodology which can be used, that is the comparable companies multiple methods, and the market price method, that is basically in case of listed companies. So these are the methodology under the market approach can be applied. Under the income approach, there are certain approaches like DCF, discounted cash flow method, where the valuers select that in the particular case I have to take the income approach, then discounted cash flow method, relief from duality method, multi-period access earning method, with or without method. So these are certain methodology under the income approaches. And under the cost approach, the replacement cost method, reproduction cost method, summation cost method, and net assets value method, NAV method. The mostly used method is the net assets value method in most of the cases. So these are the approaches and methodology which the valuer has to adopt. I am not going into the much details, but this is for the understanding. So this is what my presentation regarding the valuation. Now let us have the question answer and open session for some time, and after that we will close our session. Although it is a very interactive session and all the learned members, participants have interacted here, but still there are certain questions or certain provisions, practical difficulties which we are facing in valuation or in whatever process. Let us understand, discuss. Even outside the valuation also we can discuss. No issue. Yes, sir. The meeting is open for FAQ. Yes, Mr. Mehdi. what are the cases, sir, currently going on in your case? And where are you from, sir? Am I audible, sir?
Yes, sir, you're audible.
Yeah. So let us have some interaction, some question answers, some auto valuation, whatever it is regarding the IBC. What
I
are
think I
the
already shared
yeah.
a lot of views. I'll allow others.
Yeah,
But
yeah, on the valuation. Yes.
thank you so much for a very good session, interactive and quite well researched. Thanks a lot.
Thank you, sir. Thank you. Any other participant?
We have
Yes,
we have
sir.
learned a lot of information regarding the valuation, sir, today.
Thank
Very
you,
useful
sir.
session.
I tried to gather certain information, certain case laws, and I tried to share my experience, knowledge, and to get your experience also, because
Yes, sir.
we all are standing on the equal footing. There is no expert in this IBC. Everyone is a learner. So it is always better to have interactions and to have discussions, questions, answers. You know. So it is really a good session for me too. So,
Kindly share the PPT, sir. The PPTs are very important for us.
sir, I have shared to the IPA, and
Okay.
you can take the copy from there. Anyone from the IPA here? From the IPA, anyone is available now?
It's Radhika or Nitika?
I don't know.
Yes, there is somebody, but they are muted.
Okay. So
Hello.
ICSI. Yes.
Yes, sir. I am here.
Okay.
Thank you
So
very much, sir, for such a
and
wonderful session. The session was very interactive. I am
thank
having the PPT, sir. I will share with the participants.
yeah, I would request Anjali ji to share all the participants the PPT
Yes,
if
sir. I
they
will
could.
definitely share it.
Yeah, if they could. And any other questions we can discuss, or otherwise I can Anjali ji, with your permission, we can conclude the session.
Yes.
If
I
there
think
are
there is
no questions, then we can conclude.
I think any questions, sir? Any question from the entire IBC, not stick to the valuation? No, it's fine. Anjali, we can conclude the session.
Yes, sir. Thank you very much, sir. The
Yeah,
session was
thank
very
you.
interactive and wonderful.
Yeah, thank you. Thank you so much. Thank you, Anjali. Thank you, all the participants. Thank you, IPA, IBPI. Thank you so much. Yeah. Yes, sir.